Hello, hello, hello. Good afternoon once again. This is Dr. Olu Asekun here. So, welcome to our live podcast. Today is another beautiful Wednesday. Remember to call your friends, your colleagues at work, your family members to join us. We do this regularly on Wednesdays, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific time, and currently that is 6 p.m. Nigerian time. So you are welcome. You're welcome. Today we'll be discussing EB-1. EB-1. Can you please post the... Okay, yes. We'll be discussing EB-1 today. I know that we have been discussing all the series of employment-based ways of getting green card, but it just occurred to me that we have not really discussed EB-1 extensively. Probably because EB-1 is one of those few ways of getting green card that extremely limited number of people are eligible. That's probably why we have not discussed it today, because it's not something that is generally available to the majority of people. It is one of those few immigration benefits that I personally refer to as exclusive class. Exclusive because of the high requirement. So it's exclusive. Not many people can meet that requirement. I know we have discussed EB-2 national interest waiver in very extensive ways, but EB-1 is even, the requirement for EB-1 is even higher. It's more difficult to meet the requirement of EB-1 than EB-2 national interest waiver. So I call it exclusive club. That's my language. I call it exclusive club. But at the same time, I feel that we need to discuss it because we cannot predetermine who will be eligible and who will not be eligible. We cannot predetermine who will benefit from this information and who will not. So we just feel that it is also better to discuss it, and that is why we are discussing it today. So we are discussing EB-1 today. So if you have questions regarding EB-1, here is your opportunity. Within the next 1 hour, we'll be answering questions as it affects EB-1. Now, like I said, EB-1 is one of those employment-based ways of getting green card. Unlike most other employment categories, EB-1 is self-petition. Actually, there are three categories of self-petition in the employment-based category. So we have EB-1, we have EB-2, national interest waiver, and then we have investors, EB-5. So those three categories are self-petition. However, for EB-2, even though it is self-petition, the applicant will still have to show that it will be in the national interest of the United States to waive the requirement of a job offer and labor certification. But for EB-1, you don't even need all of that. EB-1 is in a class of its own. What are the requirements of EB-1? For anybody to be eligible for green card under EB-1, like I said, one, it is self-petition. You do not require you don't need to look for any employer. You don't need to look for anyone to sponsor you. You don't even need to show that you will benefit the national interest of the United States and all of that. You don't need any of those things. There are only two things that you need in order to be eligible for EB-1. Number one, you must show that an applicant has attained international award, a major international award. Let's say, an example of a major international award would be somebody who has received maybe a Nobel Prize, Nobel Laureate Prize. That would be a major international award. So if somebody has received a major international award, that is all you need to be eligible for EB-1. So you apply, you attach your credential, you complete the application, attach the fee, Send the application to immigration, and I guarantee you they will mail green card back to you. No interview is required except if you are applying from outside the US. If you are applying from outside the US, you will need to go to the embassy to go and apply for the immigrant visa. But if you are applying from inside the US, you don't need anything other than just to send in the application, your fee, and your credentials, and green card will be mailed back to you and your family. That is EB-1. That is one of the major requirements. That is one major international acclaim, international award like the Nobel Prize. Now, the other requirement is broken into two. If you meet the one major international requirement, that is all that is required. You don't need anything else. However, if you want to go through the other requirement is to show that you meet at least 3 out of 10 nationally or not so much internationally acclaimed awards. You have to meet 3 out of 10. Like I said, this is different from EB2 because I don't want listeners to mix this. Because even if you meet the requirement for EB1, meeting the minimum regulatory requirement does not mean that it will be approved. Because apart from meeting the minimum regulatory requirement, you still have to show that you have the national acclaim, sustained national acclaim. So in other words, except if you are using the one major international award, that one you don't need to show anything after that. I mean, that is the climax that anybody can get to in his or her profession if you win the Nobel Prize. As they say in Nigeria, they will say end of discussion. So if you get a Nobel Prize, I mean, end of discussion. There's nothing else to discuss. So that's the end. But if you are going through the second one, the B part, which require you to meet 3 out of the 10, I will list the 3. I will list the 10 later, but I want to explain and be sure that we are on the same page and nobody is misunderstanding me. So even if you meet those 3, it doesn't mean that the petition will be approved because, like I said, after meeting those three, you still have to show that an applicant have this sustained. Remember the word sustained. In other words, unlike one major international award, this one, if you are using the lesser award, you have to show sustenance. You have to show that you are persistent. It's not a one-time thing. You have to show that you are constantly, it's a repeated thing. You are up there. You have to show that you are within those class of people, exclusive people. It's an exclusive club that it's not that okay, maybe when I start explaining the individual requirement of those 10, maybe will get me better. Let me mention those 10. In the meantime, if you have questions, you can start sending in your question. If you have questions, you can start sending them in. But let me mention those 10. If you don't have the one major award, then if you are going with the 10, you need to meet only 3. Now, number 1, you have to show that you have lesser international or national awards. Lesser international or national award. Like I said, if you are using only one, that has to be sustained. If you are using only one, that has to be one major international award. That's why I gave the example of a Nobel laureate prize. But if you are using the 3 out of 10, then you have to show that you have a national or a lesser international award. It may not be a Nobel laureate prize. It may be other award in your field of endeavor. So in your field, you have to show that you have that. when I finish listing these 10, I'm still going to explain it, but I'm just listing the 10 for right now. So the first one is to show that you have a lesser international or national award. So you have to show that you have that. Then number 2, you have to show evidence that you are a member of a professional association that requires excellence as part of the requirement of membership. Now, let me say this. Whenever we were discussing the EB-2 national interest waiver, we talk about having an applicant being a member of a professional association. This is different. For EB-1, it is different. For EB-2 national interest waiver, the requirement is for you to be a member of a professional association. For example, I'm a lawyer. To show that for the purpose of EB-2 national interest waiver, all I need to show is that maybe I'm a member of American Bar Association, I'm a member of Texas Bar Association, I'm a member of New York State Bar Association, I'm a member of American Immigration Lawyers Association. That will have met the requirement for the purpose of EB-2 national interest waiver. But for the purpose of EB-1, that does not meet the requirement. In order to meet the requirement for EB-1, you have to show that requirement for membership, it goes beyond just being a lawyer. The requirement of membership actually requires that an applicant must have some level of excellence. So in other words, it is not every lawyer who is a member of the State Bar Association or American Bar Association or American Immigration Lawyers Association. It is not every lawyer. So there has to be a higher requirement. So the professional association for this purpose, for the purpose of EB-1 that we are discussing, the membership must be membership that requires excellence to be a requirement for anybody to join. So it has to be someone who requires excellence. It has to be an association that requires excellence for somebody to join. So that is why I said that EB-1 and EB-2, they are not the same thing. So I hope we are getting that very clearly. So in this case, just being a member of a professional association is not enough. In order for the petition to be approved under EB-1, in addition to being a member of the professional association, applicant must show that that professional association is limited to exclusive class of people who have to show excellence in their field in order to be a member. So it's an exclusive category. So that is very important that we understand that. Then the next one is to show that the applicant has sustained publications. Again, because we are not discussing EB-2 here. For EB-2, all you need to show is that you have publications in your field. You have publications in your field, publications that requires that is published in journals in your field. But here, it goes beyond that. That publication must be published in something that requires excellence. So it is not just that you write an article and maybe you don't have it. But if, for example, as a lawyer, I want to show publication here, it must be something that is maybe published in a journal of maybe state bar journal, something that is published in maybe American Immigration Lawyers Association journal or maybe American Bar Association journal. So it has to be something that is published in a field that is related to what you do. And of course, it has to show excellence. Very, very important. I see that questions are coming in, but I want to explain the basic this thing before I start answering the questions. So the next one is also to show that you have been asked to judge the work of others. So in other words, basically, one thing that I want us to take note when looking at the differences between EB-1 and EB-2. EB-2 emphasize specifically on excellence, emphasize specifically on being part of that top 1%. It emphasized specifically on being part of top 1% of your profession. So you have to show that it is more than just being a member of an association. It is more than just publishing things. So you must show. Somebody keep calling my phone. I don't know what's going on. Who is this person? So you have to show that you are in a position to judge the work of other professionals, other people who are top there. So as a lawyer, so in order to qualify under EB-1, I will have to show that I am in a position to judge the work of others, the work of other lawyers or other lawyers in the same profession as me. I'm in a position to recommend other people, other lawyers, or to take this decision, maybe disciplinary action against other lawyers. I hope this person is, what's going on? The same person keeps interrupting my phone. I don't know what's going on. It's a Houston number. I don't know why people don't. Please, how can I stop this? It's interrupting. So it has to be. So it has to be. What? Okay. Where's the question page? Okay, I got it. Thank you. Yeah. So what number? I think I was on number 4. Oh, okay. Okay, but I think I was on number 4. Let me try to write it so that I don't forget. Let me go over the ones that I have mentioned. I've mentioned that they must have evidence of national award or lesser international award. That's the first one out of the 10. The second one is evidence of membership in professional association. And I explained that talking of membership for this purpose is not just to show that you are a member of the professional association, but to show that the requirement of being a member of that association, it requires excellence. It is not just because I'm a lawyer and I belong to Texas Bar Association, I belong to American Bar Association. That is not enough. You have to show that the association of which you are a member, that association requires somebody to have some level of excellence before they can join. Before it's like an exclusive club. You must show that there is something, they have higher requirement, membership requirement, other than the regular one. Then after that, I talk about published materials. I think that is 3. Published article. And like I said, it must be in professional journals. It must be publications that relate to the profession, that are published in well-recognized journal that has to do with the organization. Then the fourth one, evidence that the applicant has been asked to judge the work of others. That was the fourth one. So I know I was on number 4. So evidence that the applicant has been asked to judge the work of others, to judge the work of colleagues. So that is another one that an applicant can look into. Then the next one that I can consider as number 5 evidence that the applicant has produced original scientific research. Original scientific research. That is number 5. Either original scientific research or original articles or original work, original materials, original, maybe somebody who is an athlete, maybe somebody who is maybe you are a golfer and you have won the, what is that golf prize that they win, that they wear a green jacket? You is it maybe PGA or some, this one that they wear green jacket for golfers. Well, you just have to show that you have done something that is unique, something that shows that you are on top of your profession, or maybe you are an athlete, maybe you are somebody like Usain Bolt who said okay, yeah, Masters tournament. Yeah, if you're a golfer, maybe you have won the Masters tournament. Maybe you are an athlete, somebody who has set the 100 meters world record like Usain Bolt. Maybe you have, you just have to show something that you have done that shows that in your profession you are up there. Or maybe you have a Guinness world record. You have set some record that is not common. Something that yeah, they recognize Guinness World Record. Yeah, they do. They do. Because for you to set a record, it means that you are doing something that somebody else, no one else has ever done. If somebody else has done it, then it's not a record. So for it to be a record, it means you have just done something that nobody else have done. So that sets you apart. So it's recognized. Yes, it's recognized for this purpose. So we go to number 6. Number 6, well, I think number 6 and number 4, they are similar in that both of them are talking about public. When we write exams, we used to refer to professors according to so person. He said, and I quote, you quote what they say. So when people write scholarly articles that other people in the same profession refers to and all of that, that will qualify for the purpose of number 6. Then the next one, we go to number 7, which is to show that your work has been displayed in exhibition or some, of course, maybe this may be applicable to artists. But if you have something that has been displayed at maybe major international exhibition, even if it is national exhibitions, you have works that are deemed to be of value, that it has been displayed. Remember, all you need to meet in all of these things that I'm listing is just 3 out of the 10. So I'm listing 10 right now, but all you need to meet is 3. So we are number 7. Yeah, I think we are number 7. Yeah, the number 7 I was talking about displaying artistic work. Then we go to number 8. So number 8, and I think number 8 and also number 4, they are actually similar, because in terms of number 4 was talking about you judging the work of others, but number 8 is showing that you have played a critical role in leading the work of others. So you have to show that maybe you have played a critical role in evaluating the work of others. Maybe when people in your field submit materials, maybe articles for publication, you are part of the team that review and either approve or reject it. So you have to show that you have this opportunity to review what your colleagues are doing, or to take decisions that will affect what your colleagues are doing. So that is number 8. We go to number 9. Number 9 is to show evidence that you command high salary. Evidence that you command high salary. Very important. So you show evidence that you command high salary. Number 9, high salary. Number 9. And finally, number 10, you have to show evidence that you have attained commercial success in what you do, that you have attained commercial success. For example, maybe you have published a book in your field, and that book has sold 1 million copies. Or maybe you have won an award that comes with financial. I know that Nobel laureate comes with substantial amount of cash award. I don't know the amount, but I know that it comes with some. So if you have received a kind of award that comes with financial compensation, or whatever you have done, maybe you are an artist, you have your work has been displayed in exhibitions and attracted huge amount. And of course, like I said, citing the example of that's for Nobel laureate. Okay, yeah. So the prices for Nobel laureates, I was told, is over 100. Is over how many millions?
It's 1,061,000.
Okay, over $1 million in price. But I'm even referring to artists now, or maybe sports people. For example, while I was using the example of Usain Bolt, the one that set 100-meter world record, you know that usually artists in every field, after a successful career or even a successful competition, they always attract a huge amount of money in terms of maybe they sign a contract, maybe to act as the mouthpiece for a particular brand, or maybe to advertise on behalf of a particular brand, or maybe to even become a sports journalist. Because I remember then Tony Romo, when he was a Cowboy quarterback. So when he retired, he was hired by one of these local TV stations, and they paid him probably over $100 million just to come and be a sports analyst. Yeah, that is considered commercial success. So if you are in that kind of field, or if he attracted a lot of sponsorship things. So if you have achieved commercial success, that is another one. So now, before I go into the questions, I know a lot of questions are coming in, but all these 10 factors that I listed, an applicant is required to meet only 3. But then an applicant who met the 3 may still not be approved, because there is still a requirement that the applicant must show sustained, I'm repeating the word, sustained national acclaim. In other words, it cannot be a one-time thing. It has to be sustained. The only time it can be a one-time thing is if you are using the one major international, like the Nobel laureate. Like I said, if you want the Nobel laureate, end of discussion, nothing else after that. But if you are using the lesser one, that is the 3 out of the 10, even if you meet the 3, you still have to show sustenance. You still have to show that it's a continuous thing. It's not a one-time thing. It's a continuous thing. So you have to show sustenance. So it's not that maybe you did something one time and then you got rewarded for it and then you apply for EB-1. No, they will not approve it, because you have to show sustenance. Unlike EB-2, EB-2 require a waiver of a job offer, labor certification, all of waiver. This one does not have any of those things. All you need to do is just to show that you meet 3 out of these 10. And then those 3 that you met, you have the sustenance. So you have to show sustenance. It's not a one-time thing. So that is one of the major differences. But once you meet it, it's much easier than EB2. And because the requirement for EB1 is much higher, like I said, I always call EB1 the top of the pyramid. You know, when you draw a pyramid, the bottom is always flat. Then as you go up, it becomes thinner and thinner and thinner. So EB1 is the top of the pyramid. And because it is the top of the pyramid, I can tell you in the last 20 years or more, EB1 has never, not one time, EB1 has never run out of visa bulletin. It has never run out of ability to apply for green card. There is no question of joining the queue waiting for visa to be available. EB1 has never run out of visa availability. So the question of, where are they now? They are still processing of cases filed in 2020. They are still processing cases filed in 2019. They are still in 2021. All those things does not affect EB1. And the simple reason for that is because the standard, the requirement is very, very high. And it is the top of the pyramid. So that is the reason for that. So let me go into the questions. Question 1. I don't know why so many people choose to call me at this time today. Calls keep interrupting my phone. Okay, the first question. Is this category open to any field of work? Oh yes, it is open. It does not matter what your profession is. It is open. In fact, let me say this. I've actually filed EB1 for somebody who is a photographer, professional photographer, and it was approved. So it doesn't matter. It is any field. For as long as you can show that you have that excellence, sustenance of national or lesser international award. That is all that is required. It doesn't matter what your profession is. You could be an artist, you could be a sports person, and like I said, you could be a photographer, you could be an engineer, you could be a scientist. It doesn't matter. We have done it for different categories. And like I said, I've done it for a photographer and it was still approved. So it's not the profession that I think I've already answered that. EB1 does not have anything to do with labor certification. It does not have anything to do with job offer. You don't need anything. All you need to do is that you meet that requirement. Either you have attained that one-time major international award like the Nobel laureate, or you have 3 out of 10 of lesser international or national award. But for those, if you are going for the 3 out of 10, those must be sustained. It's not a one-time thing. It has to be sustained. You must be consistent in your award. You must be consistent in whatever you do. And let me also emphasize this. Unlike EB2, even when you receive the award, for EB1 purpose, you have to show the requirement you have to show that the requirement for the award actually requires excellence. In other words, let me explain this much further. In other words, for the purpose of EB1, EB2, somebody who is in school, somebody who obtained maybe scholarship, can use it for the purpose of counting eligibility for EB2. But for EB1, it is not the same. If you obtain an award like a grant or scholarship, before you can be eligible for EB1, you have to show the requirement for that award. For example, if the award is just a grant for you to, maybe they pay granted you a scholarship and they pay your school fee, that will not qualify for the purpose of EB1, because the purpose of the grant or the purpose of the award is just for you to complete your education. That will not qualify for EB-1. You have to show that the purpose of the award, the award itself is very, very competitive. You have to show the requirement for the award that, look, these are awards that are given to the best of the best. These are awards that are given to people on top of their profession. These are awards that are given to people who are commanding the profession. So you have to show that requirement. The next question. Can I file my green card application along with the EB-1 petition? Oh yes, EB-1 petition it can be filed concurrently. So you can file the I-140 petition along with the application for green card. There is no waiting period. There is no issue of visa availability. Visa is always current. And like I said, in the last 20 years, there has never been one time when visa is not available because of the high requirement of EB-1. But yes, you can file it together. You can file it concurrently. The next question. Do scholarly journals count if I'm one of the authors? For example, I was part of many scientific journals that involves 5 or more authors. Does that count? Yes, it counts. However, the journal or the scholarly work must be such that it is something that how can I explain it? It is something that has to contribute to the profession. It cannot be something that maybe you wrote for the purpose of your dissertation or something you wrote for the purpose of applying for EB-1. It has to be something that, yes, maybe all the other co-authors, you are all on top of your profession. But yes, it can be counted if you are part of it, yes, but you must show that there must still be sustenance of excellence in your field, but it counts. The next question. Do I have to continue to work in my area of extraordinary ability when I'm in the United States? No. Once you get your green card, you get your green card. It doesn't matter whether you choose to abandon your profession after. That's completely at your choice. You don't have to. Something is interfering with my. Okay, is that a problem with our Wi-Fi? Oh, okay. Oh, sorry. What was my last question again? Do I have to continue to work in my area of extraordinary ability when I'm in the United States? That is completely that is completely your decision. It has nothing to do. Once you get your green card, you get your green card. They don't look at what you do after. They only look at what you do before the petition is approved. So, and like I said, this does not require you to look for an employer. It doesn't require you to apply for labor certification. It doesn't require you to have a sponsor. It doesn't even require you to tell them what you want to do in the US. Unlike EB-2, for EB-2, you have to explain what is your plan. What do you plan to do? But for EB-1, you don't need any of those things. You don't need to tell them what you plan to do. What you need to tell them is what you have done and what you are doing that shows sustenance, that shows excellence. That is all you need to do. Once you get that, that is it. Whatever you choose to do after is completely immaterial. The next question. Can I apply for EB-1 from abroad? Yes. You can apply for EB-1 either from the US or from outside the US. However, the procedure is different if you are applying from abroad. For example, if you are applying from the US, you can apply and file both the I-140 petition and application for green card. You can file both of them simultaneously. But if you are applying from abroad, you cannot apply simultaneously. you will first have to file the petition. Once the petition is approved, they will send it to the National Visa Center. You will submit application for immigrant visa at the National Visa Center. Once they finish processing it, they send it to the embassy, schedule you to appear at the embassy for an interview, and then once they grant you immigrant visa, you then pay for green card processing fee, and then you come back to the US. That's it. So the procedures are completely different, but yes, you can apply from abroad. The next question: can the petition be expedited? Yes, there is room for premium processing for EB-1. Yes, it can be expedited. So if you pay expedited fee, the petition can be processed within 15 calendar days or sometimes 30 calendar days. I think that with the new fee, with new immigration fee that is coming up on 1st of April, premium processing is going to change from 15 calendar days to 30 calendar days. But yes, once you pay for it, you can have your petition processed within 30 calendar days. The next question: do you need an O1 before you can file for EB-1? No, you don't. You don't. You can apply directly. For the purpose of listeners who may not understand what O1 is, O1 is the non-immigrant version of EB-1. For EB-1, one may choose to apply for a temporary visa, still showing the same requirement, but apply for a temporary visa. On the other hand, you can apply for green card directly. So it's not a requirement that you first have to apply for a non-immigrant visa category before you can apply for green card. You can apply directly under EB-1. The next question: do I have to file an application for my dependent when I file my EB-1? Well, it depends on whether you are in the US or outside the US. If you are in the US and you plan to apply for green card simultaneously with your EB-1 petition, yes, you can apply for green card for all of you, for you, your spouse, your children, for as long as your children, they are under 21 on the day you apply. Yes, you can apply for all of you, file your green card application together. However, if you are outside the US, you can only submit the petition for yourself. Upon the approval, but even though you are submitting the petition for yourself, you still have to list your family members in your petition. So upon the approval, when the approval is forwarded to the Department of State, National Visa Center will require you to submit application for immigrant visa for all of you, for you, your wife, and your children. So at that stage, they will include your children if you are applying from outside. But if you are applying from inside the US, you can apply for all of you together, including green card for all of you. The next question: will I be required to attend an interview if I'm abroad? Yes, every grant visa interview. But if you are in the US and you are applying for green card, you may not appear for interview. Your green card could be approved without you attending any interview. The next question: does the EB-1 petition allow me to work and stay in the US? Yes, if you are in the US, because you can apply simultaneously, you can file the petition as well as application for green card. If you are actually applying from the US, you can file 4 things together. You can file the petition, the EB-1 petition, which is from I-140. You can file the application for green card, which is I-485. You can file application for employment authorization, which is I-765. You can file application for travel document, which is I-131. All of these things, you can submit them simultaneously for yourself as well as for your family if you are applying from the US. That's one of the benefits of applying from the US. But if you are applying from outside the US, you can only submit the petition, the I-140 petition. It is only after approval that they will send it to the National Visa Center, and at that stage, you can include your family members. You can include your family members at that stage. The next question: who can I ask to be a reference? Well, if you are using a reference, you have to use people who are also in similar category as you. People in your field who have also attained a national sustenance. People who can be regarded as authority in your field. People whose opinion will be highly regarded. You can't just get recommendation letter from just anybody. It has to be people who are in a similar or higher situation as you. Somebody whose opinion will count. Somebody whose opinion will be regarded. So those are the kind of people that can give you a reference if you are applying for EB-1. The next question: what is the difference between EB-1C and EB-1? What do you mean by EB-1C? Well, whoever wrote this question, are they talking about intra-company transfer? Because today we are discussing EB-1, alien of extraordinary ability. Yes, alien of extraordinary ability. Yeah, that's why we listed it there. Alien of extraordinary ability. EB-2, the national interest waiver, that one is alien of exceptional ability. So that's the difference. This one is extraordinary ability. Alien of extraordinary ability. So that is EB-1. But the EB-1C, that's probably referring to intra-company transfer. Yes, so that one is a different category. So that one requires somebody who have been in management position in a multinational company who is transferring to the US. Let's say you are working for maybe Mobile England and you want to work for Mobile USA. You are a general manager in Mobile England and you want to come to Mobile USA to continue your work. You can apply for green card under EB-1C. But for today's topic, we are discussing EB-1, alien of extraordinary ability. How many publications should I have in order to meet EB-1A requirement? Well, like I said, it is not the number that matters. It is the value. It is the value of the publication. I mean, somebody may have only 2 publications, and those 2 may be significant than somebody who has 5. So it is not the number that matters. It is the importance. What is the weight given to your publication? How many people refer to your publication? What is your publication considered an authority? For example, somebody who make 1 publication, but that publication maybe in your field, maybe people who are doing postgraduate degree, people who are doing doctorate degree, maybe they will require them to go and study that publication before they can even be awarded their degree. So it depends on the value that is attached to the publication, not the number. Somebody may even have 10 publications and it may not be as valuable as somebody who have 1. So it is the value that really matters. The next question: how can I prove that my presence in the United States will provide a substantial benefit to the country? No. This is not a requirement for EB-1. Whoever sent this question is giving us the requirement of EB-2, national interest waiver. This is not required for EB-1. You don't need to show that your presence will provide substantial benefit. No, your presence may not even provide any benefit. It is immaterial. That's why I said For EB2, the national interest waiver, you have to show what are you bringing to the table, what are you going to do, what is your plan, how is the US going to benefit from what you are bringing, your skill. But that is not the requirement of EB1. That is, for EB1, it is, you don't need to show anything that you, okay, this is what I'm going to do. Oh, this is how my skill is going to benefit the country. No, you don't need any of that. It's just what is it that you have done, that you have sustained something excellent that you have done and you have sustained. That is all you need to do. So there is no requirement that you have to show any substantial benefit. No, that's not a requirement of EB1. The next question. Is it possible to file two petitions, say EB1 and EB2 national interest waiver at the same time? Well, it is possible if you are not including it. No, even if you include it, the straight answer, yes, it is possible. Because there are two separate requirements and there are two separate applications. Yes, it is possible to file it. Yes. Yes. I do know clients who filed EB2, was approved, and then decided to upgrade and file EB1. Yeah, you can file both. One does not affect the other. And of course, for the purpose of application for green card, all you need is just one approver. Even you can file multiple immigrant petitions. Apart from EB1, you can file EB. In fact, I have other clients too who filed EB5 and it was approved. Even after approval, decided to go with a family-based petition. So you can always file multiple petitions at the same time. It doesn't matter. Yes, it is possible. The next question. What information should be included in a recommendation letter, EB1 recommendation letter? Yes, like I said, for EB1, it is the value of the publication that matters. It is the value of the contribution to the field that matters. It is the sustained national importance that matters. So these are the things that must be included in a reference letter. For example, I know I just answered a previous question asking about how many reference letters are required. And I was explaining that the number does not matter. One letter may be more important than 10 letters in the case of another person. So if, for example, you have this published material that everybody in your field have to make reference to, if they are discussing your field, they have to refer to it. Let me give you a personal example. Like I said, I can only use myself as an example, and my example is also limited to my experience. So I'm going to use myself as an example. When I was in the university in Nigeria, because I went to law school in Nigeria, at that time, during my own time, there is a legal maxim that is called locus classicus. Locus classicus means the main authority. The main authority. So whenever we discuss land law at the time, no matter how beautiful your essay is, no matter how beautiful your answer is, if you don't refer to Professor Omotola, Professor Jelili Omotola, if you don't refer to him at that time, you are not considered to know anything about land law in Nigeria. So somebody like that, somebody like Omotola, if he published one article on land law at that time, it will have more effect than somebody who published 100 articles, because there is no way you can discuss land law at that time. I don't know if things have changed now. I'm talking of during my own time at law school in Nigeria. There is no way you can successfully discuss land law without referring to him. So even when you answer your question, you still have to make reference to what Omotola's opinion or position will be on the subject you are discussing. That is what is called locus classicus. That is an example of the type of thing that should be in a reference letter. I mean, imagine if I am to write a reference letter for Professor Motola. I know it's late now. We are just using this for the purpose of this explanation. If I have to give a reference letter to for Professor Motola, everything I'm saying now is what I'm going to put in the reference letter. That look, if you are discussing land law, until you refer to him, until you know what his opinion is on the subject you are discussing, your essay will not even be given any value, because they don't believe that you know what you are discussing until you refer to him. You don't have to agree with him, but at least once you mention him, then they know that yes, you understand land law, you understand what you are talking about. I don't know why Professor Motola had so much impact on land law. I have no idea. Maybe this is just my guess. Maybe he was one of those people who arranged what we used to call Land Use Act in Nigeria, Land Use Act 1978 or 1979, I don't even remember. Okay, the next question. Obtaining letters of recommendation will be difficult for me. Are these letters really that important? No, you don't have to. You don't have to. It is completely optional. So it depends on the point you are proving. It depends on how you are establishing your skill. For example, I've done several EB-1s without including letter of recommendation. In fact, in one of my earlier questions today, I talk about a photographer who did EB-1 and it was approved. I never obtained any letter of recommendation. It is more of what are you doing? What are you bringing to the table? What is that skill that you have that is national or international, and you have the sustained acclaim, you have the sustained excellence. So that is all you need. I mean, some people may be wondering, how can a photographer get EB-1 approved? Yes, they can. It doesn't matter your profession. What matters is that you have to show that you are on top of your profession. This photographer, if you have to place him among photographers in the world, he will probably be among the top 10 in the entire world. He is that good at his job. So that is what matters. That is what determines whether somebody is eligible for this EB-1 or not. And the photographer I was talking about, he has won award in virtually every country of the world, including the US. He has won Sundance. Is it Sundance? They call this festival thing. Sundance Festival. He has won award in the UK. He has won award in Europe. He has won award in the US, won award in Africa, won award in different parts of the world. So it doesn't really matter what the profession is. It is actually what is it that you have done that matters. It is not the letter of recommendation. For the purpose of EB-1, letter of recommendations are completely optional and not that important. But for EB-2, national interest waiver, letter of reference is mandatory. That's one of the differences between the two. The next question. My friend and I have the same credentials, and our EB-1A petition was recently approved. Is it safe to assume my EB-1 petition will also be approved? No, it is not safe to assume that. Every situation is different. Every applicant is different. And presentation matters. You and your friend may have exactly the same thing. Your friend may present it in a way that it is approvable, and you may present your own in a way that is not approvable. Remember, immigration is not going to do your job for you. Immigration is going to take decisions based on what you presented to them, and they don't assume. They are not going to do your research for you. They are not going to help you to look at what you have and what you don't have. It is whatever you presented to them that they will rely on. In fact, most decisions, especially when a case is denied, immigration will specifically state based on the records, that is, based on what they know, what they have. They cannot use information that you didn't present to them. Even if they know the information about you, they are not going to use it. And this is very important because I've seen clients, you tell them, go and bring ABC. You say, oh, I've given immigration this before. Oh, I've given that before. Immigration is not going to be looking at previous files. They are not going to be searching for information because they want to attend your. If you file a petition, you have to include every requirement that petition requires. So even if the requirement, if you have provided it to immigration in a previous filing, they are not going to go back to that previous filing to go and take it and then bring it to the current filing. That is not the way the system works. They will not do that. It will be your responsibility to provide adequate information, adequate requirement, adequate documentation that is required before a case can be approved. So because somebody who have exactly the same thing as you has been approved does not mean you will be approved. It is what information that is provided that matters. However, if somebody who have the same thing as you has been approved, that should give you some level of confidence that if you present your case is approvable. The next question. What is a request for additional evidence? Does this mean my case is denied? No, this is simple English. We need more information. We need more evidence. We need more clarification. They are asking for additional information, additional clarification, additional documentation. Yeah, from the name, request for additional evidence. So whenever immigration issues request for additional evidence, they are saying that the previously submitted documentation or information is not enough and they need more. That is very straightforward. The next question. Part of my achievement, I got them while in the US, but I was not in legal status. That is 10 years ago, or requirement. Because the fact that you are not in legal status in the US, that has to do with your application for. You come back to the B part, which is application for green card. Are you eligible for green card or you are inadmissible based on your previous unlawful presence? That's where you discuss that. But even though this question says that was 10 years ago, does it mean that you left the US 10 years ago, or did you? Because if you enter the US legally and then you overstay, if you step out of the US, you are only barred from re-entering the US for 10 years. So if you have spent 10 years outside the US, that disqualification will automatically drop. So that will no longer affect you. But if it was less than 10 years ago, you may still have to be disqualified for 10 years, for up to 10 years, except you are eligible for a waiver. You can always, if you are eligible for a waiver, you can apply for a waiver of unlawful presence. The next question. Oh, it's a follow-up question. Okay. My question is, if the US will consider all of my achievements despite my legal status at the time. Yes, I've answered that. Yeah, they will consider all the achievement. It doesn't matter whether you are in status at the time you obtain your achievement. What matters is, did you meet the requirement? And remember, when you are applying for green card, so everything we are discussing today, alien of extraordinary ability, EB-1, that is only the requirement for the petition. We didn't go into the requirement for green card. That's a different ball game. So what we discussed today is the requirement for the petition. So it is possible for somebody to have the petition approved and then green card denied, because they are two separate things. They are not the same thing. A petition may be approved and a green card may still be denied. So the requirement for green card is different from the requirement for the petition. But for the purpose of today's podcast, all we are discussing is the requirement of EB-1, alien of extraordinary ability, the requirement of the petition. So if you meet the requirement of the petition, your petition will be approved. Now, if your petition is approved, does that automatically guarantee green card? No. The requirement for green card is completely different. In order for you to get green card, if you are in the US, you must show that, one, you enter the US legally, and two, because this is an employment-based petition, you must show that you are maintaining legal status. So those two requirements are completely different. And of course, you must not have other grounds of inadmissibility like criminal record, or like terrorism related. So all those are requirements of green card, not. However, for those who meet the requirement of EB-1, they do not need to apply for a waiver of job offer. They do not need to apply for a waiver of labor certification. They do not even need to tell the US what they are bringing to the table. They do not need to tell the US what they will do or how their work will be of national importance to the US. They do not need to show that the US is going to benefit from their skill. All those are not part of the requirement for EB-1. So, today again, we are rounding up. We hope to see you next week. Remember to invite your family, your friends, your colleagues, and every 12 p.m. Central Standard Time, that is when we have this podcast. That is currently 1 p.m. Eastern Time. That is currently 6 p.m. Nigerian Time. And that is currently 10 a.m. Pacific Time. We hope to see you again next week. God bless you. Here is Dr. Olu Asekun. Good day.